wow. We are back on the record in case 2014-1. And we are now at issue number 4. Issue number 4 states, was P&Z's finding regarding the scale of the proposed substation expansion supported by substantial evidence? Do you hear a motion, or do you want me to make the motion?
You go ahead, I don't think we've had one tonight.
Okay.
Go ahead.
I move that P&Z's finding regarding the scale of the proposed substation expansion was supported by substantial evidence. May I have a second, please?
Second.
Mr. Haxby. All right, let me address this issue. I intend to vote for the motion. I believe there is ample evidence in the record to support P&Z's finding, and it relates to finding of fact number 3, which states the scale of the proposed substation was too large for the size of the petition site. Page 68 of the transcript, Mr. Starr testifies as follows. You, quote, you are trying to put industrial equipment in a residential neighborhood. It's tight. Can the site handle it? By criterion of measure, that's not part of the standards have been met. This one is, can it handle it? It's too tight. Has the design considered its surrounding? No. 52 feet off the back of a residential house. Is it conducive to the neighborhood? And I guess that's what really got me angry initially, etc., etc. He essentially testifies that this proposed substation expansion does not fit on the property. Mr. Adams, the representative of MEA, testified at page 121 as follows. Going back to the community, there's not a lot of flexibility there with respect to what to do. And the reason is it's a very small site. That's the problem. This is one of the smallest sites they have for a substation like this. Ms. Osiander testified at page 88. And folks, you know, I thought we caught things in the rewrite of Title 21. I thought I knew what a utility substation was until this project happened. And I based my knowledge of utility substations on that one in Steffes that I knew real well, and another one that's down off the end of Jayhawk and Birchwood, both on R6, and both of them are fine. But if we are going to say utility substations of 3 to 4 acres with massive land clearing are permitted in residential neighborhood, then the furor you see here is going to be just a minor bubble compared to what you're going to hit if something like this comes up in Turnagain. Folks will go ballistic. Ms. Dembowski, page 95. So when we talk about the size and scope of this thing, this is not, as Ms. Osiander indicated, this small thing when she was developing Title 21 that she envisioned with a substation. This is a large industrial complex that's being shoved into a residential neighborhood.
What site is that, please?
That's page 95.
Page 95.
Top of page 95, lines 3 through 7. I find that the size issue was sufficiently raised. It was recognized by the commissioners while they were debating the motion. Commissioner Spring says on page 129, where I have a problem is whether or not the project is compatible with the existing and planned land uses in the surrounding area, in the surrounding neighborhood, I'm sorry. And I've been involved in utility substation conditional uses before, and I've never seen one this big, this large, this scale of a substation anywhere in my experience. And there might be one around, but I'm not aware of it. But most of them are much smaller than this. I don't think there's any way, as the petitioner said, to come up with some type of resolution, a way to mitigate the impact on the next door neighbor in particular. It is clearly incompatible with that existing use. And it doesn't say it has to be incompatible with 10 uses or 5 uses. It just has to be incompatible with one use, as far as I'm concerned, unless somebody wants to interpret this differently. Commissioner Robinson on page 131 and 132. Line 23. That said, when I look at the standard for the conditional use and I hear the testimony and I hear the talk about this being a large facility on a small site, that pretty much sums it up for me. I look at the lot coverage requirement in the R6 zoning district and it says 30%, etc. I think the fact, line 16 on page 132. Now that said, I do not believe that we just simply shouldn't have substations in R6 neighborhoods, just like I don't believe, we need substations and we need utilities in all neighborhoods, in all parts of the community, but they do have to consider their surroundings. And finally, Commissioner Strike on page 135. This is tough for me. I'm a huge fan of the new power station. I understand. I'm not maybe in the total majority on this, but I'm convinced that we need this upgrade, an upgraded substation to be able to support the neighborhood. It's essential that we do, but it needs to be done right. On page 135, the property itself isn't conducive, I believe, to this size of structure, which is one of the biggest reasons I cannot support this. So, the finding of fact number 3 of P&Z's resolution, that the scale of the proposed substation is too large for the petition site and the surrounding residential uses, does not, or is a finding that the proposal and the petition does not conform to one of the basic standards for conditional use approval, and that is condition C, that it will be and it must be found to be compatible with existing and planned uses in the surrounding neighborhood and with the intents of its use district. And it is clear to me that both the testimony and the commissioners found that this project is too large for the size. And that for that reason, standard 3, or paragraph 3, that refers to the size, was based on substantial evidence, and therefore I intend to support the motion. Mr. Hatch.
I don't intend to support the motion. I think after looking at this, if you refer to page 122, and you look at Commissioner Yoshimura's, first, let me back up, let's go to page 121. Mr. Adams stated, we aren't into a high tower, and with respect to, for example, the discussion about height limitations, yes, the height limitation is 35 feet. But under in R6. But understand definition is the midpoint of that, the highest root. It is not the high point. Further on page 122, Commissioner Yoshimura, they start talking about, in our rewrite of Title 21, we have said very emphatically that there has to be a public meeting for projects, not after you get a footing and foundation. But you have to have a public process, and I really do feel that didn't really occur at a time when it should have occurred.
What page are you referring to?
122, 1 through 6, or 1 through 9. So basically what it's looking like, and we'll go back, Baron, to some of your citations as well. On page 88, Ms. Osiander, she's talking about, I worked really hard on Title 21. You know, a lot of you did too. I thought we caught things, but oh my gosh, I thought we knew what a utility substation was until this project happened. Effectively, what it would appear to me is that they're comparing, this project is being evaluated under the old Title 21.
Has to be.
Has to be. But they are dragging the new Title 21 back into it. And they're basically saying, look, you know, we did this new Title 21 and this should be evaluated by that. That's what I read by these statements. Many of these statements they're saying, well, we've all worked on this new Title 21, and by God, this doesn't need it. So I'm thinking that they're evaluating it under the new Title 21 when it was in fact filed under the old Title 21. The Muni came back and they said, under old Title 21, it meets the size standards. And it would, in my opinion, it would be no different than a gentleman who does something in December that's legal, and in January it's illegal, and being prosecuted for his December activity. So effectively, what's happening, what I see from this, from the commissioners, many of them worked on the new Title 21 rewrites. They're attempting to almost enforce those standards on the scale of the project, whereas under the old Title 21, it fits. And so I don't see where the scale itself is an issue. I see under Title 21, the Muni agreed it met the size standards, and that's the way it should be evaluated.
Mr. Stewart.
Well, I think one of those things that you referred to, John, was the size of the tower.
Yeah, height.
They were talking about if they moved something, they would have to put a much larger tower in there rather than a 40-foot tower, 42-foot.
Ladies and gentlemen, I'm sorry to interrupt. Those of you with an orange bag, when you guys get done, could you please put it on the security desk? They told me I need to leave now. No,
pull the orange bag and put it on the security desk?
Please.
Can we get back in the door?
You'll need to have somebody stay in. The doors are secure. Good question.
Good tip.
Sorry to interrupt.
If you didn't park, you're going to get a ticket.
I have no idea what anybody
I'm
is
sorry.
talking about. I'm still considering issue number 4.
Okay. If you didn't park with an orange bag on the thing, you're getting a ticket.
All right. Mr. Stewart, you were rudely interrupted.
I think what we're looking at here is, you're looking at it from the standpoint on specifications and will everything fit within that particular facility, within the constraints of that particular, the two lots that are combined.
Of the old Title 21.
Yes.
Under the old Title 21.
Right.
The way I'm looking at it is, old Title 21, the site met the standard. And it appears to me, from the citations that I've looked at right here, from the record, that Connie Yoshimura, Debbie Osiander, perhaps a few others in there, citations that aren't cited, said under new Title 21, I thought that it wouldn't make it. And including public process, frankly. That's not under consideration right now. But they're basically saying in here that in our rewrite of, kind of Yoshimura said on page 122, I mean, in our rewrite of Title 21, we said emphatically there needs to be public process, public meeting for the process, not after you get the footing of foundation. That probably got them all frustrated.
And that has nothing to do,
But previous to that, Mr. Adams on page 121 basically said, look, there are height limitations. With respect to that, that would go to size, scale of the project. If you go back to page 88, Ms. Osiander stated, that she had worked hard on Title 21, and so scale of the project, it appears as being evaluated under new Title 21, or they're trying to. And as I understand it, under conditional use, it has the historical uses of the property, is that correct? Shall be compatible with historic Baron?
no,
Didn't you just say that?
not at all. What it says is, it will be compatible with existing and planned land uses in the surrounding neighborhood.
Right? But
That's
keep
what it
going,
said.
there were some additional conditions in there.
And with the intent of its use district.
Keep going, there were some more in there that you brought up about
Nope.
historical uses.
Nope,
They're all on page 2 of the memo.
yes, those are the standards, and I'm looking at standard C. Page 2 of the memo.
Okay, so I guess, did it conform to the standards for use and title and regulations under the original Title 21, or the original land use that they filed under? That's a question I have.
But the issue is that the commission found that this project is too large for the area. And that addresses paragraph C of the standards. Will it be compatible? Will this new project, will it be compatible with existing and planned land uses in the surrounding neighborhood and with the intent of its use district? Now, we know what the intent of the use district is. It's residential. It's R6. So the question is, first of all, it is only allowed in an R6 district with special permission, with conditional use.
Which it had prior to this date, as a
No,
utility substation.
no, it did not.
Wasn't it existing?
No, it did not, because the utility station preceded the zoning in that area.
So the utility
Okay.
station was there.
If the small utility station was there, we're talking about the expansion.
Right, I understand. Okay, so, but there was an existing utility station there,
Correct.
and did they already own all of the land?
No. They purchased an additional lot
When?
right before this hearing.
Is it correct that the existing substation was not given a conditional use? It was just treated as existing?
Correct.
Okay, so there never really was an officially zoned conditional or decided conditional use?
It was
No.
probably a certificate of public
No.
convenience.
They were
No.
lawfully existing though because
Yeah.
they predated zoning.
Predated zone. The issue is, as we come back to the motion, was the finding of excessive size and not fitting into the neighborhood, was that supported by substantial evidence? That is the issue of the motion. And I believe there is ample testimony in the record to support P&Z's conclusion and finding that it does not fit into the neighborhood, that it is too large for the neighborhood.
Okay, clarify something for me.
Okay? I'll try.
It says the commission found that the substation meets some of the conditional use standards. However, the scale of the proposed substation was too large for the size of the petition site.
In other words,
It says it's too,
Too
it's
large
too
for-
massive.
Too large for the petitions,
it's-
that has nothing
yeah.
to do, it's eliminated itself from the surrounding area. It has to do with size of the petitions.
This, what they are proposing is too large for the size. In other words, just as Mr. Adams says, this is a very small lot to put this gigantic structure on.
well, it is. And
Yes.
he was asked to try to change it, change the entrance, to put a bigger buffer zone on one side. And he said that they couldn't do it just because of the clearance requirements and everything else that they had to put into the site.
Well,
The engineering clearances.
Yeah.
Sure.
Safety concerns.
What is, Bob, what does that say again? You just read it out of there?
The scale
the
of the proposed
scale of the
substation.
proposed substation was too large for the size of the petition site.
So that's the issue.
And is that statement supported by sufficient evidence? By substantial evidence, I'm sorry.
Too large for the size of the petition site. So it has nothing to do with surrounding neighborhoods, doesn't have anything to do, it has just to do with the size of the petition site.
Well, because that refers to standard C of the general conditional use standards, which is, will it be compatible with existing and planned land uses?
Okay, so there's actually two ways to kind of look at it. One is from a technical standpoint, where physically does it fit within that site? And the other is
Is it
subjective. Is the people that were on the P and Z looked at it and said, it's my subjective opinion that that site is too large for that community.
I mean, the structure is too large.
Right, it's going to be too large for the R6 zone.
Correct. And the question is, was there sufficient testimony to support that conclusion? That's the gist of the issue.
If you defer to the judgment of those commissioners, then there would be.
And that's all that this motion addresses. Is there sufficient evidence in the record to support that opinion of the commissioners?
I don't think we need to be, we can look at an actual physical site, which is, I think, what the Muni did.
Well, what the Planning and Zoning Commission resolution says is that the scale of the proposed substation was too large for the size of the petition site. We've already dealt with mitigation measures previously. The scale of the proposed substation was too large for the site, or for the size of the petition site. That's it. We're not dealing with anything else. We're not dealing with the adjoining neighborhood. We're not dealing with the adjoining areas, the use of the surrounding neighborhood compared to this. All we're dealing with is, was there adequate testimony, is there the record support that this thing is too big for the petition site?
Right.
So, where does it say, what section of testimony.
Mr. Starr on page 68. Can the site handle it? Has the design considered its surrounding? No.
Hold on, the surrounding has nothing to do with it. It's not in this. This is just
It
the
does.
petition. No, it doesn't. It's
course it
listed, their finding has only to do with the size with respect to the petition site.
Yes, but the size relates to a standard. It needs to fit in to conditional use standards that are enunciated in AMC 2150-020. And paragraph C says, will it be compatible with existing and planned land uses in the surrounding neighborhood?
That's not
And
what
with the
they're,
intent of its use district. And they are saying, and the commission said, this is not compatible because it's too big.
where does it say that? Show me in the resolution where it says that.
Well, I thought I just read it to you. The scale of the proposed substation is too large. In other words, this thing is too large
Well, you've cut off the sentence, please, read the rest.
for the size of the petition site. This structure is too large
Okay, so
in
show,
that petition site.
so show me where that relates to anything else that we're talking about here. Does it say in there, what did you just state in the, coming out of the,
Yep.
out of the muni code for a conditional use?
Will it be compatible with existing and planned uses?
They didn't say it doesn't, it's not compatible with the existing
Well,
uses, or existing.
Isn't that what it means when they say it's too large? What it means is it's not compatible.
No, if you cut the sentence off correct, the scale of the proposed substation was too large for the size of the petitioned site, period.
Yes.
That's it. It
Yes.
doesn't say about, has nothing, doesn't say anything else about adjoining uses, other uses, it just says, if they'd have meant that, they'd have said that. If they'd have said
Well-
it doesn't meet additional surrounding uses, other than that, they would have said it. They didn't say it. They said it's too big for the size of the petition site. That's it.
Correct.
I'm not gonna reach around,
Correct.
I'm not gonna reach around and try and pull some other meaning out of that. I'm gonna just say, okay, is the scale, does the scale of that thing, is it okay on the existing site?
And
If
they
it's
said
okay-
no.
They said no,
Yes.
but the record basically says, according to the MOA, says it's okay under the
But
old
we're
title.
not, we don't care what the muni says.
Well,
The-
we're right, we don't care what the media says, but they didn't say, the PNC did not say it doesn't meet the surrounding uses. They said it's too big for the petition site.
Yes.
That's all, which
Yes.
means that it doesn't meet code for the petition site.
No.
It does meet the code.
No, it doesn't say that. What it means is it does not meet the conditional use standard.
That's not what it says here.
But that's clearly,
That's
it
what
all
I'm
needs
saying.
to tie into
That's
the
what they have to
conditional
look at.
use standards.
That's what they have to look at, but they didn't identify that. They said it's too big for the existing site. Their engineer, MEA's engineering department said it meets the site. MOA said it's okay for the site. Under the old Title 21, or the old code, it meets the standard.
The gist of the motion, of the issue is there sufficient evidence in the record to support that finding? That's all it is. We're not saying whether the muni is right or the engineering department is right. It simply relates back to evidence in the record.
Right.
That's all it does.
So the motion is that the finding that the scale of the project is supported and too large for the petition site. That's your motion.
The motion is, was P&Z's finding regarding the scale, or is P&Z's finding regarding the scale of the proposed substation expansion supported by substantial evidence?
And too large for the petition site?
No.
No?
just by substantial evidence regarding the scale, is the statement regarding the scale supported by substantial evidence? That's all.
But to
Okay, so-
clarify, the statement is that the scale was too large for the petition site.
Correct, because that's what paragraph 3 says.
And is there substantial evidence for that,
To say that it's too large for the petition site,
for their decision?
for their decision.
Yes.
There's a lot
substantial
of,
evidence.
there's a lot of talk about it.
Well, that's-
There's talk about it in the record,
That's precisely
there's-
what we're saying.
but is there?
That's the gist of the
But is
motion.
is that evidence of it?
Of course.
If somebody talks about it, is that evidence when you've had a review by a municipal board or a review by a municipal department that says, yeah, it meets it for for that site, they can put this on there?
The gist of the motion is there sufficient evidence in the record to justify their statement in paragraph 3? And I have given you 8 citations where the scale is addressed in the record. And so
Objective.
I'm saying there is
Subjective.
sufficient evidence in the record to support that statement number 3. That's all we are saying.
That the scale of the proposed substation was too large for the size of the petition site. That you're saying that there's enough evidence to say that the scale of the proposed substation was too large for the size of the petition site.
Yes. To support that statement, that's all. There could be contrary evidence. That's not the point. Is there sufficient evidence in the record to support that statement by the commission? That's all the motion addresses.
I think there are a lot of feelings, I don't think it's evidence.
Well, but it's opinions by planning and zoning.
Commission, by the planning and zoning commissioners. So it's their,
What about-
based on their opinion.
What's their opinion based on? What is their opinion based
Well,
on?
in one of
Isn't
them.
it based, let me finish,
Mhm.
isn't it based on the testimony of Starr, and I quoted it earlier? Isn't it based on the testimony of what Mr. Adams, the MEA representative, says, which basically says, this is the smallest lot I've ever seen for this kind of thing, Osiander and Dombowski. And they all said, this is too large for the site. And that's what the commission agreed with. And that's what the motion addresses, regardless of what the Muni found or the engineer found or whether it's technically possible to put it on there or not. That's not the gist of the motion and of the finding. The finding simply is it's too large for the site, and our finding, in parentheses, and our finding, by the way, is based on the evidence of a bunch of people who showed up here. That's all. Rightly or wrongly, doesn't make any difference. The only question is there enough to support that finding in the record? That's all it addresses.
Okay, well, it's my turn on.
Okay.
Take a whack at it. I believe that on 95, page 95, Ms. Dombowski. Was talking about Ms. Osiander indicated somewhere, Ms. Osiander, they continue talking about when they were developing Title 21. I assume this is the rewrite of the old ones. It's a large industrial complex shoved into a residential neighborhood. I think.
That's what it says, yeah, I agree.
I think that they're mixing and matching between what they submitted under and what the new Title 21 said. That's my opinion.
Okay.
So if I were to look at this, I would not support your motion because the Planning and Zoning Commission resolution says that the scale of the proposed subdivision was too large for the size of the petition site. And Muni comes back and says, no, it didn't. The engineering people went through it, they reviewed it, and it's, so I won't support it.
But the only question is, it is immaterial whether the Muni came back and the engineers came back. The only thing that counts and that this issue addresses is there sufficient evidence for the commission to make that finding? That's all it addresses. It doesn't address whether that is a correct statement or not, or whether it is in fact too large. It is simply, does the evidence support the evidence through testimony or whatever else is in the record, does that support the commission's finding? That's all.
Okay?
Okay. Mr. Stewart.
Well, I think if you look at what Mr. Adams said, it's so small in size, at least where it can fit, that they don't have any other alternatives. So if they wanted to change the entrance, they would have to put a much larger tower inside that structure. That larger tower would clearly be incompatible. So what, I guess what he's saying is that this is really,
Although it states in there,
there's not much, there's no room for maneuvering.
although it states in there that under the old Title 21, there are no size limitations, height limitations. Under the old, what they submitted under, it states there are no height limitations. There are none.
That's correct. You're correct.
So there are no
Height
height,
limitations.
there are no height limitations whatsoever under the standard in which they should have been judged. There were none.
Yeah, but if you switch it around and you put a 72-foot tower in there,
They could do that.
yeah, then that clearly would be incompatible.
No, they can't.
With the uses.
No, they can't unless it is compatible with the surrounding area. That's all. Because that's what the conditional use standard
Well,
requires.
But there are plenty of places.
No. Look at this. And not whether there are plenty of places. If they want to put a 72-foot tower in here, it still has to comply with the conditional use standards. And one of the standards is it compatible with the R6 zoning district?
But that's not what we're talking about. We're
Yes,
talking
that's what
about that
we're
it's
talking
too
about.
large for the petition site.
Yes. Is the structure too large for the petition site?
Yeah, we're not talking about compatible uses around us. We're talking about.
Yes, we are, because it relates back to standard 3.
But that's not what they state. That's not what they state, Barry. I disagree that they state that it doesn't meet surrounding uses. They state that it's too big for the petition site. And the engineering came back and said, it's fine, it works. The Muni came back and said it works. That's in the record.
And there's a bunch of people who testified
That it doesn't.
Correct.
Right.
And that's the only thing that the motion addresses.
Right, but who do you listen to?
That's not the question.
Okay,
That's not the question.
okay.
The only question is there enough in the record to support the commission's finding? That's all. No more.
Support the commission's finding of what?
That it is too large for the site. That is the only question.
Okay, that the commission's finding that it is too large for the site. Has nothing to do with surrounding uses, has nothing to do with anything else. Only that it's too big for the existing site. Correct?
Yes, because it doesn't,
Because it doesn't fit
Okay.
the conditional use.
No, that's not what we're talking
Yes.
about. Only the site. It's too
Correct.
big for the existing site.
yes, but it refers to the conditional use standard of compatibility with the surrounding area. That's the standard it addresses. All right, Mr. Stewart, any additional comments?
No, I'm ready to vote on this.
All right, Mr. Stewart, Mr. Hagsby, are you ready to vote?
Yeah, I'm ready.
All right, Madam Clerk?
Aaron Kirkchow,
Yes.
Robert Stewart,
Yay.
John Haxby.
No.
The motion passes by a vote of 2-1. Issue number 5. Was MEA denied equal protection by P&Z applying requirements to the conditional use application that are not required by code to other similarly situated entities? And this is a legal issue. And may I have a motion, please, that incorporates this issue? Mr. Stewart?
I move that MEA was denied equal protection by the Planning and Zoning Commission.
Applying requirements.
Applying requirements to MEA's conditional use permit application that are not required by code or applied to other similarly situated entities.
Okay, second?
Second.
That's me. Mr. Stewart?
You know, I don't think that they were denied equal protection, but I do think that the hearing itself, in fact, and I'm looking at both hearings, the hearing.
No, you can't. I'm sorry,
No.
point of order. You cannot look at the previous hearing. It is not part of this case.
Okay, even though it's added as an exhibit?
Not part of this case.
Okay. Well, I looked at, you can take official notice of code, right?
Well, it is part of, yeah, the code is part of what governs this application, yes.
I think that the, under Anchorage Municipal Code 21.10.010, the Planning and Zoning Commission is told that they should be impartial. And the preside, under 21.10.302, the presiding officers should ensure fundamental fairness in proceedings before the commission. I think they were not denied equal protection, but it was a chilling environment because of the comments that the commissioners made. But I don't think that it rose to the one of being denied equal protection. They were given the opportunity.
You're not addressing the next issue. I'm sorry.
Whoops.
We are at issue number 5.
Hang on.
He's addressing it.
Yeah, equal protection.
Okay. Continue, please. I merely wanted to be sure that you addressed issue number 5 and not issue number 6.
Well, to me, they kind of are intertwined. I guess, okay, strictly from an equal protection standpoint, the appellant has argued that Chugach Electric handling by the planning and zoning is different than MEA's handling through the Planning and Zoning Commission. But I don't think that it arose to a equal protection denial of equal protection. I think what it did is that it brought forward a very caustic environment by the frustration by the commissioners. And I think that provided a lot of animosity, and I don't think that that was interpreted by, I think, the appellant as denial of due process, because Chugach Electric actually, in their situation, went out and did conduct some public hearings before they actually went to the planning and zoning. They weren't required to do it. Just like here, they weren't required to do it. So I don't think it was an equal protection issue. I do think it was a bit of an unfairness issue. But it did not rise to the level of being denied equal protection.
Okay. Mr. Hacks.
It would appear to me that yes, there was a lot of frustration on the part of the commissioners. And sometimes concerns, I've seen it before, that need to be addressed turn out to be requirements. Saying an escrow account when MEA has adequate insurance to cover any potential problems of a neighbor or anything else turns out to be a requirement. Others, Chugach Electric being allowed to do substations on lots roughly the same size within similarly zoned areas. I think that Matanuska Electric Association could expect to be treated similarly. It's the way we do it in the building business. We expect this was approved. We can probably be expected to be treated the same way. The MOA's position, coming back and saying, and approving the study, and saying that it did meet code, I say gives MEA the ability to say, we were treated differently. And the thing that, that's typically bothersome to me is the suggestion that they should establish an escrow fund. It seems like extortion. So I'd say they were treated differently and deny equal protection.
Okay. Let me weigh in here. This issue addresses 2 points by the appellant. The first one is a comparison with the Chugach Electric application that apparently was earlier. We have no idea what the situation was with Chugach Electric. Each parcel of property is unique, and each parcel of property faces different conditions and conditional use standards. While they are and will be applied uniformly have different effects on different properties. We have no record of the Sugarge Electric case before us. We don't know what happened in the Sugarge Electric case. Just by saying they were granted a permit in an R6 and we are not, what do we know what the conditions were? What do we know what the adjacent property uses were? We don't. So we are unable to determine the validity of the allegation that was made by the appellant. Consequently, I can't find that that was an equal protection denial. The second issue addressed by the appellant under this, or the second set of facts addressed by the appellant under this particular issue is that by, quote, requiring larger yard requirements and suggesting an escrow funds, MEA was treated differently than others similarly situated. Well, the resolution makes clear that there was no requirement of a larger yard requirement, of a larger setback requirement, or a requirement that an escrow fund be set up. That's not, when we come back to paragraph 5, it simply says these were concerns that needed to be addressed. It doesn't say we require you to set up an escrow fund. Also, it doesn't say we require you to lower the pad by 8 feet, or we require you to provide a 50-foot setback. It doesn't say any of these things. All it says is these were concerns that needed to be addressed, but were not adequately addressed, really. And that does not rise to a denial of equal protection. And it is for that reason that I will vote against the motion. Any further discussion? Mr. Stewart, any further discussion?
None.
Mr. Haxby?
Yes.
Okay. Go ahead, please.
Well, there were sometimes the way these things are written and sometimes the way they're delivered. It's either do these things or you don't get them. Suggestions, as I said, are not always suggestions, they're demands. And that's what I view these as. If we throw out the Chugach Electric piece, we say, yeah, we can't consider that or shouldn't consider it, I can agree with you. We don't know anything about it, I buy that. But I also know that suggestions aren't always suggestions, they're demands. Either do this or it isn't going to be approved. I've seen it before. And so, for that, I will vote that they were denied equal protection.
Any further discussion? Seeing none? Madam Clerk, would you call the roll on the vote, please?
Please
I'm sorry.
restate the question, or the motion.
The motion is MEA was denied equal protection by P&Z applying requirements to the conditional use application that are not required by code to other similarly situated entities.
A finding of yes is,
That there was a denial of equal protection, and a finding of no is that there was no denial of equal protection.
okay?
Does that address your concerns?
Yep.
Okay. Mr. Stewart, does that produce any additional comments by you or not? No?
No.
All right. Let us vote, please.
Mayor Kuchar,
Nay.
Robert Stewart,
No.
John Haxby.
Yes.
The motion fails by a vote of 2-1. Issue number 6. We are getting there, folks. Was MEA due process by P&Z by A, providing the public extended time to testify and failing to offer the same opportunity to MEA, and B, by not having its case heard by a fair tribunal. You're all getting a little tired here, but we need to address this issue, and I will make the motion to make it a little easier.
Thank you.
I move that MEA was denied due process by P&Z by A, providing the public extended time to testify and failing to offer the same opportunity to MEA, and B, by not having its case heard by a fair tribunal. And
Second.
Seconded by Mr. Haxby. I will address, this is a legal issue, and I will address it. In reviewing the record, I find that there was no member of the public who spoke in favor of the application. That is absolutely true. And there were quite a few people who testified. There were 3 former assembly persons, and there were several people who live in the vicinity, and there were others. But P&Z offered MEA an opportunity, first of all, to postpone and come back and produce further evidence and testimony. And I refer specifically to Commissioner Yoshimura's exchange with Mr. Adams on page 116 and 118. And I'm referring to Commissioner Mulcahy, who on page 136 says basically he is sorry that MEA did not ask for additional time and for a continuance, because clearly the commission, and I think we would all agree that the sentiment was from the commissioner's comments that if they had asked for an extension of time to present further evidence or to address further issues, that would have been granted. So, reviewing the record as a whole, there was ample opportunity for MEA to be heard. And in fact, Mr. Adams, representing MEA, asked for 1 minute rebuttal at the end, as is customary. It extended much further than 1 minute. There's nothing in his testimony. He, as representative, would have had to raise the issue. Hey, we haven't had enough time here. We want to present more. Give us additional time. And as is customary before planning and zoning and the other land use boards, that will always be granted within realms of reasonableness. And the way that is done by commissioners frequently is that they say, now, petitioner or witness, do you have some other issues that you wish to bring up? None of that occurred here to the extent that Mr. Adams wanted to say anything else. In fact, the gist of his closing statements was, we have gone as far as we can. We want you to vote this up or down. And that's precisely what he said when he had the exchange with Commissioner Nishimura. So I do not see that MEA was denied additional time that they could have asked for. They could have asked for time, it would have been granted. They didn't. Consequently, there was no denial of due process, just because there was a larger number of people who testified against the proposal than there were people who testified in favor of the proposal. Doesn't mean that there's a denial of due process to the applicants. Regarding issue B, not having the case heard by a fair tribunal, I think this board bent over backwards to accommodate MEA. Yes, there was, and we all have talked about it before, there was a great sense of frustration by the board, but the sense of frustration arose out of the fact that MEA was not willing to go back and deal with this issue any further. In reviewing the record as a whole, I'm left with a firm impression that this was a fair tribunal. It discussed the public's objections with MEA. It tried to explore alternatives, lower the pad, set up compensation fund, extend setbacks, but MEA was unwilling to entertain them. So the board was really bending over backwards to accommodate MEA. And there's ample testimony, and I've read it here in the record before, where several commissioners said, yes, we need substations, we really need substations. But this is not the right way to do it. In other words, they wanted to accommodate the construction of an amendment to the substation, or to a remodel of the substation, but they could not do it under the conditions that had been presented to them. That does not mean that it was not a fair board. And I must tell you, when you look at the comments of the commissioners, there is nothing in there that is unfair to the petitioner. Now, the fact that they denied the application, you can say, you know, that's unfair that they denied the application, but where is it that they treated the applicant unfairly? That's the gist of the second portion of the equal protection argument. And I must tell you...
Well, we're on due process, correct?
Correct. Because if the petitioner were treated unfairly, that could rise to a due process issue. And I must tell you, based on the record as a whole, I do not find anything that would support that. Yes, there was unhappiness with MEA, but that does not mean that they were treated unfairly. I do not believe that the record shows that they were treated unfairly. So I do not intend to support that portion of the motion either. Yes, sir, Mr. Haxby.
Is it true that under the old title that they were to be reviewed by, that public process is not part of that?
I'm not sure that I understand the gist of your question.
Well,
The
there's-
amended Title, let me just finish.
Okay.
The amended Title 21 requires more interaction with the community
Right? And the
That's true.
And the previous,
than the previous one.
and what does the previous require?
Apparently, it does not require as much interaction as the public wanted in this case.
So,
Or as the commissioners thought that maybe they should have done voluntarily.
okay, and so they may have been treated differently.
How?
Well, because some of the commissioners were part of the rewrite of Title 21, stating, well,
Well, they presumably all were.
right, presumably all were, and
Yeah.
under the previous conditions, they didn't need to have that public input. And under the new conditions, they did. So they applied a different standard than they should have been evaluated on. It's kind of like in your situation as a lawyer, you try under, let's say you're a lawyer in the Bahamas, and you're trying U.S. law in the Bahamas. You're not trying Bahamas law in the Bahamas. Okay, so were they in fact, was there more public input? Was there more public input that was brought into the situation that should have been? And one of the statements in here, I'm not even going to go to the appellant side of it, but in our brief, it said, MEA had 2 attempts under 2 separate public hearings before P&Z to do so. P&Z expressed irritation because it was weary of hearing and debating a poorly designed project.
Who says this? Is that the appellee?
That's the appellee.
Okay?
Okay? And so it's clear to me that P and Z was weary and frustrated and just said the heck with it.
I don't think the record supports that statement at all.
Well,
The record
do
doesn't
you,
support that.
do you think that that if they'd have come back for a third bite at the apple, that it would have turned out differently?
If they had asked for a continuance and would have been able to address these issues that are listed here in the resolution, it's entirely possible that it would have passed.
Under,
Entirely possible, if they had addressed those issues. But that's pure speculation, really.
and I find it, that it was their belief that it was a poorly designed project. Wasn't
I
stated.
think that's a fair inference.
Yeah.
That's a fair inference.
Only because if they had, the muni supported it, municipality of Anchorage supported it, they said it met code. They said their engineers designed it, they stamped it, said it meets code. And everybody said it met code. The only ones that said it didn't meet code in the record were the commissioners. They're the ones that had said it doesn't meet the code, doesn't meet the standard. Yet the muni, which has more detail on the code and which knows how to apply the code, said it did meet the code.
But they're not the ones who make the decision.
They may not be the ones that approve it, but they're the ones that make the decision whether or not it meets the codes. They're the guys that are the pre-approval process, or the guys that issue the building permits. So they're the guys that say it meet code. So they have electrical engineering department, mechanical, civil, structural, the landscaping, they've got all of it, and nice.
So
And so they're talking about a poorly designed project, and they're applying standards in here which are not part of the deal. They're not part of any code that I see.
So how does that relate to the issue, which is,
Due process?
was MEA denied due process by providing the public extended time to testify and failing to offer the same opportunity to MEA? That's the one issue.
Okay, and in
Does
that-
not relate to approval at all.
In-
Simply relates to process.
Right, and in that standpoint, under the old code, I don't think that process was required.
Wait a minute, we are talking about providing the public extended time to testify at the public hearing. That's all we're talking about.
Due process has to do with applying the standards, correct?
No, it has to do with treating the people who, in this context, treating the people who come before you equally and fairly. And the gist of the appellant's argument is you allowed more people of the public to testify than people in favor of the petition. And that's simply not true. Just because numerically there were more people testifying against it than there were for it, doesn't mean that the people who were in favor of the application and who had fewer supporters there were treated unfairly to the extent that it rose to a violation of due process.
Okay, so is your motion include both A and B
Yes,
in one shot?
in one shot.
Okay, so,
If you would like to separate them, be my guest.
okay, I would be in favor of separating.
Well, make a motion.
I would make a motion to separate A, denial of due process by the Planning and Zoning Commission providing the public with extended time to testify and failing to offer the same opportunity to MEA, and B, making it a two-part question.
Okay, I understand. Is there a second for the motion?
I'll second for discussion purposes.
Okay. Mr. Haxby.
I would probably agree with your point that just because there are 20 on one side, one on another, that it's not a denial of due process. So I would probably vote yes. I would agree to that part of it. The Fair Tribunal, I think there was too much frustration, probably some antagonization between the parties. Both of them got frustrated, and I think P&Z just said to hell with it. So I would say they were denied due process of a fair tribunal.
Mr. Hansky. Mr. Stewart, I'm sorry, apologize.
Okay, I don't think there's any problem with the due process issue. MEA was given a chance to rebut, and it started on page 105. There were a lot of questions, and they went all the way up into page 115, where MEA was extended additional time. So that initial thing about the appellant had 1 minute to rebut in their filing. Well, that's not really what happened. There was plenty of due process allowed MEA throughout that particular hearing. With reference to the second half about the fair tribunal, I think it was kind of a caustic environment that was going on, and that should have been, I think, the realm of the official that was in charge to kind of keep that down and stick to the facts and stick to things that referred to what they were considering, not chastising people for what they should or should not have done. But I don't think that rose to the level of unfair tribunal.
I do not intend to vote for the motion. As I said before, first of all, I agree with both of you regarding the A portion of the motion, if we can call it that. Regarding the B portion, there is ample evidence to support that the commission bent over backwards. Yes, there was frustration there on their part, but they bent over backwards to help out the petitioner, MEA. Here is testimony from commissioners that I wrote down here. We need substations, but they need to consider their surroundings. As currently presented, I cannot support it. I really wish, another one, I really wish the petitioner had asked for postponement rather than us having to vote this up or down. Finally, I want to make sure, so those comments to me indicate that they were trying to do the right thing under the circumstances. The fact that it, for MEA, didn't turn out this way doesn't mean that this was an unfair panel. In fact, I do not find anything in the record from any of the commissioners that have voiced, that spoke up in this case, anything. There is nothing in the record that shows that they treated MEA unfairly. And it is for that reason that I intend to vote against the separation of the two motions. Or to separate the one motion into two, I should say. Any further discussion?
Okay, so this one will be the vote on the separation?
Yes.
Okay.
Yes.
All right, so summarize it, yes, no?
So really, your amendment first is to delete the B portion.
Separate them.
To separate. Okay, so,
Separate A and B.
all right, that's probably the easiest way to handle the amendment. The motion is to separate A and B from the main motion.
Yes separates them, B, or no,
Yes.
does not separate them.
Correct.
Okay, got it.
All right.
Okay,
Does that clarify it for you?
yes.
Mr. Stewart, does that clarify it for you?
Yep.
All right. Madam Clerk?
Aaron Kuchow,
No.
Robert Stewart,
No.
John Haxby.
Yes?
The amendment to separate the two issues from the main motion fails, and we are now back to the main motion, which was my motion. MEA was denied due process by P&Z by A, providing the public extended time to testify and failing to offer the same opportunity to MEA, and B, by not having its case heard by a fair tribunal.
I
Is there
think
any-
it should be and/or, because if you say and, then if you found one and not the other.
Okay,
So
I
I think-
will accept that.
We've already said they aren't separate.
They are not separate.
So if it's and or, that will separate them.
Yes, so we should not separate those.
No.
But if you say, if the motion is and, then
It lumps it into one.
Lumps it into
And that's what
That's what
the
he's
gist
done.
of the motion is.
Barron has kept them together,
Yes,
so it's and.
it's and.
so if they were denied due process by not being a fair tribunal, then the motion,
No, we've already voted that this is all one,
It's all one
I
deal.
know,
one
but by-
denial of due process.
We have not
Just
separated them.
different phases of the same due process denial.
So if we say, yes, they were denied due process, it's for all. If we say, no, they weren't denied due process, it's for all.
Exactly.
We just lumped them all.
We thumped them all together. Do you have a problem with that?
I do, because I think by using the word and, then.
Okay, so I understand. So you want us to really vote separately on each one of them? That's really what you want us to do?
Barron, I got my way. No.
So that's really what you want us to do? And it
Yes.
would probably make it easier. So,
Yes.
You're gonna go back on the record and-
we are going to backtrack here. Mr. Stewart, you understand what we are saying here?
Yeah.
So I will rephrase my motion and I will put it in I will make two motions out of one, okay? And the first motion that we need to vote on is MEA was denied due process by P&Z by providing the public extended time to testify and failing to offer the same opportunity to MEA.
Okay,
And
second.
Mr. Haxby seconded
I'll
that.
second that.
Any further discussion regarding that motion?
No.
Seeing none, Madam Clerk?
Aaron Kuchow,
Nope.
Robert Stewart,
No.
John Haxby.
No.
The motion fails by a vote of 3-0. Next motion related to that. MEA was denied due process by P&Z by not having its case heard by a fair tribunal. And Mr. Haxby, you seconded that. Any further discussion regarding that motion? Mr.
There's-
Stewart?
Substantively, I don't think it was it rose to the issue of being an unfair tribunal. But I do think that the environment that that hearing was held in was not conducive to good community relations and working together with people back and forth.
Okay.
And I think that is the responsibility of the presiding officer on the Planning and Zoning Commission to keep that in check and keep it a civil proceeding, which I don't think they did.
Okay. But as it relates to the motion?
But as it relates to the motion, I don't think it rose to the one of being an unfair tribunal.
Okay. Any further comments by Mr. Haxby regarding it?
No.
Okay. I have no further comments either. I made my comments before. We are ready to vote.
Aaron Kuchow,
No?
Robert Stewart,
No.
John Haxby.
Yes.
The motion fails by a vote of 2-1. All right. Now then, we have addressed all 6 issues. And we need to consult with our trusty lawyer here where that leaves us. It seems to me that the only thing we did was that we modified a particular paragraph, but that does not substantively change the outcome of the Planning and Zoning Commission's decision. Am I correct?
Well, what you found specifically was that the Planning and Zoning Commission's finding that the mitigation measures proposed were not sufficient to adequately buffer the surrounding residential uses was not supported in the record by substantial evidence. And then you substituted, the board substituted its independent judgment with respect to finding that the mitigation measures with respect to lighting, noise, drainage, and landscaping were sufficient to adequately buffer the surrounding residential uses. So really, the question comes down to, if you're finding that the scale of the proposed substation was too large, means that one of the criteria for the conditional use was not met, then you affirm the Planning and Zoning Commission, because if any of the requirements for the conditional use weren't met, the conditional use request is denied.
But we already disposed of the size issue, did we not?
Yes, you already ruled that the scale of, that there was substantial evidence in the record to support the finding that the scale was too large for the size of the petition site.
Okay. So it seems to me that that does not in any way then, even though we changed one finding of the commission, that that does not change the outcome. It does not change the decision of the commission.
It's probably a good idea, though, to discuss that and vote on your final.
Okay, so what you're suggesting is that we make a motion that on the basis of the prior findings, on the basis of the decision on the 6 issues, that the decision of the Planning and Zoning Commission is affirmed. Okay, and I will make exactly that motion so that it's on the table.
So your motion is?
So the motion is that on the basis of our decisions on the 6 issues that were discussed and presented, the decision of the Planning and Zoning Commission is affirmed.
Okay, I'll second the motion.
Okay.
We're gonna vote on
It seems to me that, as you could hear from my comments with Ms. Cusco before, that the fact that we changed one of the findings does not change the fundamental nature of the decision of the Planning and Zoning Commission. In order to overrule the Planning and Zoning Commission, we would have to find, on the basis of the 6 issues that we have discussed and voted on, that all standards for conditional use approval as mandated by 2150/020 were met, and there hasn't been, that has not come up at all. And it is for that reason that I would vote for the motion to let stand the decision of the Planning and Zoning Commission as written, except for the one finding regarding the mitigation. And we had the 4 or 5 issues, I can't remember now how many there were. I think there were only 4. That, in other words, that in spite of the rule, our substitution of our judgment regarding those findings of fact, that does not change the fundamental nature of the Planning and Zoning Commission's decision, and that therefore the Planning and Zoning Commission's decision should be affirmed. Mr. Haxby, you seconded my motion.
Yeah, I second your motion. There's not much, I mean, we've debated this ad infinitum. I don't have any discussion necessarily, not at this point.
Okay.
It's fairly clear to me.
Mr. Stewart?
No, I think we beat this enough.
The horse is dead.
Do you agree with the motion?
Yes.
Any further discussion regarding the motion, which is in essence to affirm the decision of the Planning and Zoning Commission as contained in Resolution 213-159, except as modified as to one section? That's it?
That's it.
Yes.
Yeah, I'm ready to vote.
Okay. We're ready to vote?
Aaron Goodchild,
Yes?
Robert Stewart,
Okay,
John Haxby.
No.
The motion passes by a vote of 2-1. Next, we need to discuss, I need to caution or advise so that it goes on the record that the method for appeal of what we have done today is governed by, Sally, help me out, by AS 2130. Huh.
Do you have your code? Yeah.
What's the section? Oh, I can come up with it. Hang on.
Chair Goodchild,
Yes,
can I get, it's 10 o'clock, can I get a motion to extend?
I move that we extend the time for hearing this
Second.
by 10 minutes.
Second.
Any discussion?
None.
Everybody in favor?
all in favor?
All in favor?
Aye.
It is 21:30:095. All right. Ms. Cusco, when can you have a version of what we did tonight to us? How much time do you need?
A week.
A week? I don't have a calendar with me, but today is the 17th. We need a couple of days to at least think about it. We don't need to come together for this, do we? No, I don't think we need to. I think we just, do we? I cannot recall.
Yes.
We do.
You have in the past, you've always
Okay,
gotten together,
good.
because
We
if there's
will.
any changes or things you want to modify, you can't discuss it
Okay, so then the question is,
except in public.
can we meet 2 weeks from today, to give you 1 week and for us to fiddle with it and do whatever is necessary? And 2 weeks, Madam Clerk, 2 weeks from today would be?
Well, I'm trying to get to my calendar. Okay, so 2 weeks from today. oops,
31st?
The 31st.
Yeah, the 31st,
Okay.
Thursday the 31st.
Mr. Stewart and Mr. Haxby, are you available on the 31st?
Yes.
To get together at 5:30?
Yes.
Okay. Madam Clerk, are you available?
Yes.
Okay,
Can you email us the schedule so we can just look at it? Thank you.
all right, so we will meet in 2 weeks to consider and hopefully approve the final version of findings of fact and conclusions of law and decision. And it will.
Are we meeting here?
Yes, and we're meeting here,
5:30, yeah.
5:30 on the 31st. And the findings, conclusions, and decision will be in conformance with what we have discussed and decided today.
Okay.
Thank
And
you.
I will have them to you guys by the end of next week.
Okay. And do you have a good email address for Mr. Haxby, because he didn't see your memo?
Yeah, I did not get your memo.
It said you received my email.
Is there a better email address for you, perhaps?
No, that should do it.
Do I need to give you a call to make sure that
Yeah,
you
I
read
will.
it?
Yeah, I'll give you a call.
Or Sally
I'll
will?
call,
Either
make
one.
sure, yeah.
Just give me a call.
Okay.
That's fine.
All right.
Sorry.
Next item on the agenda is, are there any comments by the three of us that we have, either about tonight or about the good of the order? Anything you need to?
The help was great. The food was nice. Thank you.
All right. Mrs. Stewart, anything else you wish to mention? Okay. I have nothing further. With that, we are concluding tonight's meeting, and I will entertain a motion to adjourn.
So moved.
It's been moved by Mr. Stewart and seconded by Mr. Haxby that we adjourn. There being no objection, we are adjourned.